When my grandfather passed away, he left me a 3,800-acre Wyoming cattle ranch that had been in our family for nearly a century. Along with the ranch came every original deed, survey map, and property record dating back generations. I believed I knew every fence, pasture, and road on that land, until one routine survey changed everything. The ranch had always shared a border with a quiet HOA subdivision built years earlier. We respected each other's property, and I had never questioned where the official boundaries stood. Everything appeared peaceful on the surface. That spring, I hired a licensed surveying company before replacing several miles of old fencing. I wanted every property corner verified before investing thousands of dollars in improvements. Accuracy mattered more than assumptions. 3 days into the survey, the lead surveyor called me with an unusual expression on his face. He asked me to meet him near the subdivision entrance immediately. His measurements didn't match what everyone believed. The completed survey revealed something almost impossible to believe. Nearly 60 completed HOA homes had been built inside the legal boundary described in my family's recorded ranch deed. I checked the measurements again, hoping there had been a mistake. Instead of reacting emotionally, I contacted my property attorney the same afternoon. She advised me to gather every deed, subdivision plat, and county filing before speaking publicly. The facts would have to come first. The county records office produced decades of certified documents showing the original ranch boundary had never changed. Every official filing supported the survey's conclusion. The paperwork was remarkably consistent. Before taking legal action, I requested a meeting with the HOA board. I calmly presented the survey results and suggested we work together to understand what had happened. I hoped cooperation would solve the problem. Karen Lawson dismissed the survey almost immediately. She insisted the neighborhood had existed for years and claimed that history alone settled the matter. I asked if the HOA had any recorded documents proving ownership. The meeting ended without agreement. A week later, I received notice that the HOA had filed a lawsuit asking the court to declare the subdivision's boundaries valid. My attorney smiled and said, "Now we'll let the record speak." During the discovery process, both sides exchanged thousands of pages of legal records. My attorney organized every deed, survey, tax record, and subdivision filing into chronological order. The history of the land slowly became unmistakable. An independent title company reviewed every recorded transfer connected to the subdivision. Their investigation traced ownership back more than 40 years. Each document was compared with the original ranch records. The court appointed an independent surveying company to verify both sides' claims. Modern GPS equipment measured every property corner without influence from either party. Everyone agreed to accept the professional results. When the final survey was completed, it matched my family's original deed almost perfectly. The only paved entrance serving all 60 HOA homes crossed directly through my private ranch property. The courtroom battle suddenly became much more significant. My attorney filed a survey with the court and asked the judge to recognize the confirmed property boundaries. We also proposed discussing a lawful access agreement before the case went further. The next decision would belong to the court. The first court hearing attracted homeowners, county officials, surveyors, and local reporters. Most residents believed the HOA would easily win because the neighborhood had existed for years. The judge reminded everyone that property ownership will be decided by recorded evidence, not public opinion. My attorney presented the original ranch deed, tax records, historic surveys, and county plats dating back nearly 100 years. Every document pointed to the exact same property line. The consistency immediately caught the judge's attention. The HOA argued that the subdivision had existed peacefully for decades and that moving the boundary now would create hardship for homeowners. My attorney acknowledged those concerns but explained that courts must follow the recorded chain of title. Facts had to come before assumptions. The court-appointed surveyor testified that modern GPS measurements matched the original government survey almost perfectly. Every property corner aligned with Ethan's historic deed. The courtroom quietly absorbed the significance of that testimony. County land officials confirmed that no amended boundary had ever been legally recorded. The original ranch description remained active in every official record. The courtroom grew noticeably quieter. After reviewing the evidence, The judge issued a temporary ruling recognizing the survey as accurate while the case continued. Until final judgment was entered, my ownership of the entrance road would remain legally protected. That single decision changed the balance of the case. Following the hearing, I sent the HOA a formal proposal offering a legal access easement while negotiations continued. The agreement included reasonable maintenance costs and liability protections. It was a practical solution that benefited everyone. The HOA board rejected the proposal without offering an alternative. Instead, they insisted they already owned permanent access. With negotiations over, my attorney advised me to enforce my property rights within the limits of the law. Following the court's temporary order, I installed a secure gate across the private ranch entrance road. The gate allowed authorized ranch traffic, but clearly marked the road as private property. Every step followed the court's guidance. The next morning, HOA leaders arrived demanding that the gate be opened immediately. I politely handed them a copy of the court order and explained that the matter remained under judicial review. The discussion stayed respectful. A county sheriff arrived after receiving another complaint. After reviewing the court documents, he confirmed that the dispute was civil in nature and encouraged both sides to continue through the legal process. Everyone remained calm. Over the next several weeks, engineers studied possible alternate access routes across neighboring public land. County officials worked with planners to identify options that wouldn't require crossing private ranch property. Progress slowly replaced conflict. The final court hearing focused on ownership rather than